Hello everyone, I'm Joyce though. I just finished my internship at the Hague Conference Permanent Bureau this August. This video is my attempt to discuss the interaction of the common law trust and cryptocurrency through the lens of a very recent case, Huyen and Darby. I hope it will somehow spur further interest in this very interesting topic among experts. Let me tell you a little bit about the facts. Wang and Darby is a case decided by the English High Court in 2021. It involved a complex dispute between two cryptocurrency traders over a transaction of Tezos and Bitcoin. Wang, the claimant, owned a significant amount of Tezos, which he wanted to be exchanged for Darby's, the defendant, Bitcoin at a later date. The claimant asserted that the Tezos he had transferred to the defendant was held by the defendant on trust, while the defendant maintained that the transaction was essentially a repo arrangement, which consequently precluded any trust arising in respect of the Tezos. In this case, the court eventually excluded the existence of a trust over those Tezos, ruling that a sale-purchase arrangement for ownership of the asset, in this case the Tezos, was fatal to any trust analysis. However, a point to note is that it was agreed by the parties as well as the court that as a matter of English law, a unit of token of Tezos can constitute property, which can, in principle, be held in trust. The court did not have to decide on this question. As far as English law is concerned, courts are in the affirmative that cryptocurrency can be considered property. In 2019, the UK Jurisdiction Task Force published a legal statement recognizing crypto assets as tradable properties. This line of thinking was also endorsed by a line of case. Notably, in AA and Persons Unknown, the High Court decided that Bitcoin and other cryptocurrencies can be considered property under English law because they meet four criteria. First, definable. Second, they can be identified by a third party or third parties. Thirdly, they are capable in their nature if there is an assumption by the third parties. And fourth, and finally, they have some degree of permanence. This criteria was marked by Lord Wilberforce in National Provincial Bank and Ainsworth in 1965. In a relevant matter, a New Zealand High Court case, Rusco and Cryptopia Limited, has confirmed that cryptocurrencies as digital assets are a form of property that are capable of being held on trust. These cases show that within common law countries at least, there have been an effort from the judiciary to provide for the application of trust and property rights in the context of a digital economy. The notion of trust, however, is quite unfamiliar to civil law system like mine. I wonder how Wang and Darby will be resolved if somehow it makes its way to a civil law jurisdiction court. One thing for sure, private international concerns will be present in all aspects of the dispute. Firstly, the pseudonymity of users and the decentralized nature of cryptocurrency make it extremely difficult to decide on the status of the transaction. Where the transaction happens, we'll never know. Moreover, regulations of many domestic legal institutions have been deemed to be very insufficient to address the difficulty raised by the cross-border nature of cryptocurrency. Secondly, The applicable law matters a lot since it characterizes everything from the characterization of cryptocurrency itself or the relationship between participants in the system. Where the trust discussion is relevant, thirdly, the law applicable to the proprietary effect of cryptocurrency towards third parties, such as the issuers of crypto securities, the takers of crypto collateral, parents, the session, and everything matters. Last but not least, the jurisdiction of the courts to hear the dispute related to the outcomes of self-executing smart contracts and the recognition and enforcement of such outcomes will be of very important discussion. Considering the proliferation of cryptocurrency and future development of this cross-border payment mechanism, it is very important to take note of Huyen and Darby and the potential issues that can arise out of this case, as well as future cases. I want to wrap up with some questions relevant to CODIFI that I think very worth contemplating. While the trust is the most distinctive institution of Commonwealth systems, it is generally held that trusts are quite incompatible with the basic assumption of civil law systems. Hypothetically, is there any chance parties can enforce a decision like Huyen and Darby in a jurisdiction with no trust at all, or if parties have brought a parallel proceeding in another jurisdiction with another instrument analogous to trust? At the time of this video, the 2019 Judgment Convention has met the criteria to enter into force. Will this provide a way out for the parties without recognition of trust or cryptocurrency as property in their jurisdiction? Another question is that how will the 1985 Trust Convention be applied in this digital economy? Last but not least, will the 2015 choice of law principles become even more significant, as it is proven that choice of law is really what matters? Well, legal certainty will definitely be desirable for parties participating in cryptocurrency transactions. I believe the outcome of CODIFI and current as well as future HCCH instruments can help achieve that. That is the end of my video, and I hope everybody enjoyed the CODIFI conference. Thank you very much.